Hello everybody. Those of you who wait with bated breath every fortnight for Slade's Property Slice will know that there was no vlog 2 weeks ago due to unforeseen circumstances, so apologies for that. I will try and make it up in the near future with 3 slices in a row so I can achieve my ambition of 26 slices in 2023, one every 2 weeks. Now today, the simple question in my vlog is what happens to an underlease when a headlease is terminated. So you have a headlease from landlord L to tenant T, and tenant T has granted a sublease to subtenant S. What is the effect of the sublease from T to S when the headlease from L to T ends? Well, it depends on how that headlease ends. The easiest and happiest scenario for the subtenant is where the headlease ends by surrender, where landlord and tenant voluntarily and mutually end the headlease before its contractual term expires. A surrender does not terminate the sublease. So the effect there is that following the surrender, the head landlord becomes the immediate landlord of the subtenant under the terms of the sublease. Now contrast that with the headlease terminating as a result of service of a break notice by either the head landlord or the head tenant. Regardless of whether or not the head landlord or the head tenant serves the break notice, the sublease also ends. In that scenario, the subtenant may have a claim against its landlord, the middle tenant, for derogation from grant on the grounds that it contractually agreed a sublease that isn't there anymore following the break. In practice, however, it would be unusual for a tenant with a break option to grant a sublease for a term which extended beyond the break option date, or to grant a sublease which could not itself be broken on or before the headlease break date. Forfeiture next, i.e. if the head landlord terminates the headlease under its forfeiture clause on account of breach of covenant by the head tenant. If a lease is forfeited, any sublease granted out of that forfeited lease falls away. It's also terminated. However, the subtenant has the right to apply to the head landlord for relief from forfeiture. And the 2 forms of relief for which the subtenant can apply are for the grant of a new lease to the subtenant on such terms as the court sees fit, but not for a term longer than the original term of the sublease, or for the vesting of the tenant's lease in the subtenant. So there are some protections for the possibly blameless subtenant in the forfeiture scenario. Disclaimer of the headlease by a liquidator of the head tenant. If that happens, any existing sublease will fall away. However, the disclaimer of the head tenant's liabilities does not bring to an end the subtenant's liabilities. The subtenant is entitled to continue in occupation of the property, but provided it complies with the tenant's obligations contained in the headlease. However, the subtenant can't enforce the landlord's covenants in the headlease unless either there is a direct contractual relationship between the subtenant and the head landlord, which there might be under the original license to sublet, or unless the headlease has been vested in the subtenant. It's all very complicated in a disclaimer scenario. In that scenario, the head landlord and the subtenant may need to work together to settle new arrangements between them. Finally, if the headlease ends by expiry of the contractual term, but a subtenant occupies the premises at the end of its contractual term for the purpose of its business, and that subtenant has statutory security of tenure under the Landlord and Tenant Act 1954, then the subtenant will have 1954 Act renewal rights against the head landlord. As with disclaimer, that's another quite tricky, involved scenario which will necessitate specialist legal advice at the time, depending on the circumstances. That's all from me today, and I'll see you all again in a couple of weeks' time.